Hello, everyone. Welcome to the 2024 Hot Topics and Environmental Law Summer Lecture Series. I'm Christophe Courchain. I'm the Interim Director of the Environmental Law Center and the Director of the Environmental Advocacy Clinic, as well as an Associate Professor of Law here at Vermont Line Graduate School. We're very pleased to welcome you to the presentation today. Each talk of these in this series is worth 1 Vermont CLE credit. So please keep track of your records of which ones you've attended. We'll have time at the end of our presentation today for some Q&A. So the way that you participate in that, if you're watching us on the main link on our webpage, it goes to the VLGS YouTube page, and you can just enter your questions in the chat. I will be able to parlay those to our speaker, and we can have a robust discussion towards the end of the hour. But I will introduce our esteemed speaker today, Anthony Maffa. Anthony is a professor of law at the University of Maine School of Law and is now serving as the school's Associate Dean for Innovation. Professor Maffa's research and writing focuses on the legal tools available to combat the policy challenge of global climate change, drawing on the fields of environmental law, administrative law, criminal law, property law, and international law. Just a small plate. Professor Maffa oversees at the University of Maine the Environmental and Oceans Law Certificate program there. So in addition to teaching courses in the environmental law curriculum, he covers the core subjects of torts and trusts and estates. In recognition of his teaching, he received the Professor of the Year Award in 2018 and in 2021. Prior to joining the Maine Law faculty, Professor Maffa served in the General Counsel's Office of the U.S. Environmental Protection Agency, and he clerked for Judge Dennis Saylor on the United States District Court for the District of Massachusetts and Judge Kermit Lopez on the United States Court of Appeals for the First Circuit in Portland. Professor Maffa graduated magna cum laude from the Wharton School of Business at the University of Pennsylvania and earned a law degree from Yale Law School. And so we're very, very privileged to have Anthony here with us today. He will present a talk on holding fossil fuel companies accountable in Vermont and beyond. Indeed, a hot topic. And so please join me in welcoming Anthony Maffa.
Thank you, Christophe. Thanks for that wonderful introduction. I'm pleased to be here today, and thanks to VLGS for inviting me to give this talk. I'm going to share my screen because I do have some slides, but I assure you they'll be worth it. So I'm going to start off. I want to start off with just by saying, by way of introduction, Christophe did a pretty good job there, and I've been teaching torts for many years now at Maine Law, pretty much since I came here 8 years ago. So that's an area that I've increasingly been focused on, and it'll end up featuring pretty prominently in our conversation here today. And I want to center this conversation on what I and many people have thought about as the sort of waves of private civil litigation around climate change. And I'm going to talk about them, and you'll see this is kind of a theme in the presentation about these waves. And the way I like to think about this is I consider us now to be in that third wave, which is where we're going to spend a good amount of our time at the end of this conversation. But I think it's worthwhile to start at the beginning with that sort of first wave of climate litigation. And before we even get to that first wave, it's important to note that what I'm talking about here when I talk about these waves of private litigation around climate are primarily cases that find their foundation in tort. And so there's a whole bunch of other types of climate litigation out there. There's administrative litigation. There's, in the Supreme Court, where we have West Virginia versus EPA and Massachusetts versus EPA and all these other types of actions that I'm kind of setting aside for the purposes of this conversation. And what I want to focus on is just the private cause of action that in some ways all kind of trace their roots back to the common law and tort. And so that's why I just want to center us there to begin with. So that brings us to the first wave here. And the first wave, and bonus points if you can and identify in I guess in the YouTube chat what these famous waves are that I'm using for these slides. But the first wave I like to think of as coming about really cresting in the early 2000s. And this first wave of climate litigation really focused on what we consider to be the sort of foundational environmental torts, right? So trespass, nuisance, public nuisance, private nuisance. These are the traditional causes of action that we had prior to the environmental regulatory state that functioned as the way to police people who were putting things into the environment, or onto land, or into water that were harming others' property and their health, right? And so if we think about this as sort of the foundational tort concepts, it's not hard to see why these were the first go-tos for private litigants seeking to, vindicate climate harms, either future harms or even present harms that they were beginning to experience even at this time in the early 2000s. The initial plaintiffs in these cases tended to be state governments and tribe, and in one case, in one very important case, a tribal entity as well, or a federally recognized tribe in Alaska. These cases tended to be brought against defendants who were fossil fuel emitters themselves, and in some instances, also the government who was responsible for regulating those fossil fuel emitters, right? So think about power plants, what we call in the Clean Air Act, stationary sources of greenhouse gas pollution. The owners and operators of those facilities became the target of this first wave of climate tort litigation. That litigation really has two cases that kind of formed, at least in terms of popular and scholarly attention, the sort of core of how we ended up where we ended up. And those cases are American Electric Power versus Connecticut, and the Kivalina versus Exxon case from Alaska. These cases are very similar in some ways, but because at the core of both cases is a nuisance action, and both cases assert that these emitters of fossil fuels are creating a public nuisance in one case the citizens of Connecticut, in another case the tribal community in Kivalina. But they are also different in one important respect, or at least there was some thinking at the time that this difference might be important, and that's that the Connecticut case was looking for injunctive relief, right? An order from the court that would restrict the continued emissions by the defendant entities. The Kivalina case was seeking money damages, primarily because the community in that case was faced with the proposition of having to either spend a lot of money to fortify their current existing land community, or to really to move, and they needed funds in order to accomplish that task. So, but as I mentioned, at the core of both of these cases is the same type of tort, right? But they're both nuisance cases, right? Well, one of them reached the Supreme Court of the United States first. That's AEP versus Connecticut, right? And famously, big wipeout at the Supreme Court, 8-0 against Connecticut in favor of American Electric Power, right? The Supreme Court, Justice Ginsburg, writing for the 8-0 court, wrote that the Clean Air Act held that the Clean Air Act displaces the federal common law of nuisance as it relates to air pollutants like greenhouse gases. In other words, if your nuisance claim is brought in federal court and is premised on some common law notion of nuisance, that claim it no longer exists because the Clean Air Act has displaced it. Think about, if you can remember all the way back to your first year civil procedure cases, we're talking about an Erie versus Tompkins type of situation. Is there federal common law in this area? And the Supreme Court said, no, not with respect to air pollution and nuisance, because the Clean Air Act covers that area, at least as it relates to federal torts actions. Now, as I mentioned earlier, there was this distinction between the cases where AEP versus Connecticut was looking for injunctive relief, which is the traditional relief at common law for a nuisance action. But Kivalina sort of more or wisely was looking for money damages, something would be easier for the court to theoretically facilitate. After AEP versus Connecticut was decided, the Ninth Circuit held that AEP versus Connecticut also precluded Kivalina's continued action, even pursuing money damages. In other words, this Clean Air Act displaces a federal common law action for nuisance as it relates to climate change, regardless of whether or not the plaintiffs are seeking injunctive relief or monetary damages. So that is the first, what I call the first wave. What is important to note before we move on to the next wave is that the Supreme Court, in this decision wiping out these claims, did leave a sliver of window open for nuisance actions premised on state common law. And we'll see that that's sort of a preview of at least part of what describes the second wave of climate change litigation. So that second wave, it describes pretty much the space we've been in over the past 10 years or so. AEP versus Connecticut was decided in 2011. Since then, federal common law nuisance is pretty much off the table. So plaintiffs have turned to state law to vindicate these claims. In these cases, it tends to be the situation that the plaintiffs are states and now localities, so municipalities within those states, and the defendants. The scope of the defendants has shifted in this second wave. We see now defendants in these cases as not just emitters of fossil fuels, but primarily the producers of fossil fuels, right? The extractors of the fuels, the refiners of the fuels, the people who are importing fossil fuels into the United States, like oil and coal. And so it's a little bit of a shift in focus in terms of defendants. It gets you, it creates a different, in torts terms, it adds another step in the causal chain. But there's a number of reasons why that strategic move was made. In addition to expanding the type of defendants we saw pursued in the second wave, we also expanded the types of causes of action that plaintiffs were pursuing during this time, right? And I shouldn't say it as if this time has passed. We are still sort of in the midst of this. We added new torts, and primarily we added products liability torts. Now, traditionally in products liability, there are three causes of action, right? You have a defect in manufacturing, a defect in design, or a defect in warning, or a failure to warn. In the context of climate change, we really focus on the latter two, right? Because there are no claims in any of these cases that I'm aware of that somehow the fossil fuel products that were being burned and creating greenhouse gases were defectively manufactured. In other words, weren't manufactured to specifications, right? They were manufactured to specifications. Those specifications just so happen to result in a lot of greenhouse gas emissions, which is a defective design claim, right? And similarly, they were not accompanied by any kind of warning about their propensity to perpetuate the problem of global climate change and the attendant consequences of that crisis that we are now facing. In addition to these products liability claims, we also saw the addition of fraud and unfair trade practices, right? Which it focused on, or at least in some instances found their basis in the consumer protection statutes on the books in various states. The theory behind these cases is that fossil fuel producers materially misrepresented, primarily through omission, but also through active mischaracterization, the risks to the public of continuing to burn their products for fuel. And the evidence here is quite remarkable. I won't go through it all with you. You can find out more about this on the internet relatively easily. There's a few different investigative journalism efforts that have been quite substantial, tracing back internal documents within the American Petroleum Institute, but also of specific entities like Exxon, showing what they knew about climate change, dating all the way back to the 70s. And you see here on the slide, right, that just one example of that on the left-hand side. The most serious problem with catastrophic global warming is it may not be true. That's from an ad from the API in the 1980s, I believe. And so they were actively perpetuating this campaign of misrepresentation, and that misinformation campaign forms the core of these sort of fraud and unfair trade practices causes of action that have been added to these complaints in this second wave. Many of these cases are still alive, right? We are still watching to see whether they wipe out. It is also worth noting that at the same time that these cases are progressing, there's this parallel movement, which I mentioned sort of caveated in the beginning, of these cases against the government only brought by youth plaintiffs, right? We have Montana versus Held as an example of a success, right, in that area. But in this private tort litigation, these cases are still pending throughout the country. And if you look at this map, you can see sort of a representation of where those cases are. By the way, the Hawaii on this map, I pasted it in. If you're a geography buff, you'll know it's not quite that close to the west coast of our country. But let's just focus or zoom in a little bit on where we are, at least where I am and where many of you probably are, the east coast of the United States, and in particular Vermont. A lot of these cases are in various stages of litigation. In the Vermont case, the Attorney General, as I said, on behalf of the state, is filing a lawsuit naming Exxon, Shell, other oil and gas companies. So there you have example of going after the producers of fossil fuels rather than the entities burning the fossil fuels. You'll see that there's a failure to warn claim described in there, and that case is still pending as far as I know. Right, similar cases, right? The Eastern Seaboard, the Massachusetts case, which is, if you're familiar with Massachusetts law, proceeding under their pretty strong consumer protection law within that state, is moving relatively rapidly, as is the New Jersey case. But there's a lot going on in this area, and as I said, it's still something to pay attention to. We still aren't quite sure where it's going to end up. But you may also be aware that many of these cases have been embroiled in challenges attempting to remove the cases from state court to federal court, and thereby get a federal court to essentially throw them out based on the previous precedent of AEP versus Connecticut. And so far, those efforts have failed, right? The Supreme Court did at least partially consider this issue in the Fourth Circuit Baltimore case, although that is probably going to be relitigated at the Supreme Court when all of the issues of removal are presented to the Fourth Circuit at the same time. I won't get into all the details on that, but just to say that there's an effort to remove these to federal court in hopes that that will stop them. The effort to remove them to federal court also has the benefit to the defendants of prolonging the litigation, and ends up with a tremendous amount of briefing and oral argument and opinions at the circuit court level, even about the removal issue, before we even get to the merits of these claims that I've been mentioning, whether that be products liability, nuisance, negligence in some instances, failure to warn, consumer protection. All those things are sort of swept under the rug, awaiting the decision on some of these more procedural issues like removal, and that's slowing these cases down, right? Slowing those cases down is, I guess, one reason why we've seen the development of a third wave of climate litigation, which is where I want to focus the rest of our time. And I kind of went rapid fire through those first two waves because I want to focus like a laser on this third wave, because the third wave is where you're probably most interested because of some recent developments within Vermont. So the third wave I characterize as a man-made wave. And I say that because to distinguish it from the others, because the causes of action in this third wave are statutory causes of action generated for the purpose, at least in one instance, for the purpose specifically of holding fossil fuel producers accountable for the harms of climate change. Now, you might be thinking, where is there a tort-like statute that holds people accountable? Well, you probably immediately jump to CERCLA. At least that's what I did. And that's when I wrote this article a year and a half ago or 2 years ago now about proposing a federal statute analogous to CERCLA that would impose liability with respect to climate change. And that should sound familiar to many of you because Vermont has something similar that we'll talk about in a minute. But before we get there, it's worth pointing out what it is about CERCLA that it has made it so impactful in terms of imposing liability in the contaminated sites case, right? We're drawing an analogy to that situation where we had thousands of contaminated sites throughout the country. How are we going to clean them up? How do we use CERCLA to change the tort basis that would have provided potentially the ability to recover money to clean those sites up and make it streamline that process, make it easier to collect funds to do that and get moving on actually cleaning up the country. The key features of CERCLA, if you talk to anyone about it, are that liability it imposes is strict, it's joint and several, and it's retroactive, right? And so strict joint and several retroactive liability is, by statute, has made CERCLA more potent than the underlying torts that it replaces, right? Almost no common law cause of action is going to let you achieve the retroactive relief that CERCLA lets you achieve. You eliminate some of the problems with causation by imposing strict liability. With joint and several liability, you are able to capture all of these myriad of polluters who sometimes pollute the same site. Now, Vermont and New York now as well decided that they weren't going to wait for the federal government to do something like I propose in my article. They just did it themselves, right? They passed what we call the Vermont Climate Superfund Act, or that's what folks are calling it. And it's no coincidence that they're calling it a Superfund Act for climate change, right? They're directly analogizing it to this type of CERCLA liability. So if we take a look at the statute, and I promise I don't have too many wordy slides, this might be the wordiest one I have, but I want to look at the statute a little bit more closely and compare it to CERCLA, or compare it to those defining features of CERCLA and see if we can find them in the text, right? And I'll start with section 598, which is where the statute as enacted imposes liability, right? Who does it impose liability on and how? And so let's look, I'm looking for the words in here that are analogous to those three key features of CERCLA. So right away, strictly liable for their share of the cost. So strict liability, it's there, right? Retroactive liability. Now I've bracketed it because it's complicated, because it describes it in the statute as the covered period. But essentially that covered period is 1995 through 2024. So yes, retroactivity all the way back 30 years to 1995. What about joint and several liability? Well, not quite. Look at the other language I have highlighted here. The cost recovery ratio, right? We're not talking about joint and several liability for all of these producers. We're talking about proportional liability in this situation. Right now, before we get to exactly what that proportion looks like, let's talk about why that might actually make sense. As opposed to a contaminated site where you have a defined number of contributors in a situation where it's very difficult to parse out who's responsible for what type of contamination, you can get away with imposing joint and several liability where they can interplead one another and negotiate as to who's responsible for how much of the cost of the cleanup of one particular site. And there are tons of these isolated sites across the country. With respect to climate change, there are lots of isolated climate costs across the country, but the impacts that create those costs are global in nature. And so the number of potentially responsible parties is going to be the same in every situation, and it's going to be the same potentially responsible parties in every situation. All of them put emissions into the air. So at some point, someone is going to have to decide who bears what proportion of the costs in any given situation where you have to pay for climate adaptation. And this statute is just doing that work ahead of time. And you can debate whether it makes sense to do that as a policy matter in the legislature, or to just have imposed joint and several liability and forced companies to argue about who should pay what percentage of a particular cost recovery demand. But Vermont has gone with that former choice. They've done it here in the statute. So how have they done it? They made it, if you read this paragraph 598B and you convert it to an equation, and I apologize for anyone who, like my students, hates math and sort of cringes every time I put a fraction or an equation on the board, but this sort of screams for one. So let's do it. If you remember ratios from middle school or high school, here you go. I've highlighted in green the demand to an individual PRP, potentially responsible party. I'm porting that term over from CERCLA. That's our X that we're trying to solve for, right? And what is that X according to the statute? It should be equal in proportion to the total cost of Vermont of dealing with greenhouse gas emissions, right? Climate change adaptation, and in equal proportion to the potentially responsible party's share of greenhouse gas emissions over the covered period 1995 to 2024, over the total number of greenhouse gas emissions, right? So a hypothetical party that is responsible for 10% of greenhouse gas emissions from 1995 to 2024, right? Or 10 out of 100 on the right-hand side, would then be responsible for, let's say it's costing Vermont, I'm just pulling these numbers out of my head, $100 billion. They're going to be then responsible for 10 billion of that $100 billion according to the statute. It's relatively simple, especially with those numbers that I put forward. But I want you to hold on to that, because one part of this equation, though it's not the variable we're solving for, could be a problem. And we'll return to that in just a moment. But before we get there, I want to focus on the process of how we even impose the liability under this new Vermont statute. So CERCLA litigation, in contrast to this, can famously be initiated by EPA or by potentially responsible parties who sue one another. Right now, because we've removed the joint and several liability piece of this, we haven't really created a private cause of action here at all with this Vermont statute. Right? What we have is just administrative initiation. The agency shall issue a cost recovery demand under the statute. So Vermont, the government of Vermont, is issuing the cost recovery demand to the potentially responsible parties, right? And then there's another provision of the statute that sets out the time that's required to pay that cost recovery demand to the administrative agency in question. Now, you may be wondering, well, what if I don't agree with what the agency says my client has to pay? And the first step in that is a requirement written into the statute that you exhaust administrative remedies, in particular by asking for reconsideration with the secretary after you receive the notice of a cost recovery demand. Only after you go through the process of that reconsideration request can you, and then receive a final notice of cost recovery, only then can you demand to be in court, right? And it puts you in the civil division of the Superior Court of Washington County in Vermont to pursue that, essentially that judicial appeal to your cost recovery demand. That's where the litigation finally enters the picture here, right? Back to the original theme of this talk. So let's go back to the equation for a second and talk about this other part of it that might be jumping out to you as questionable. And that, at least for me, very quickly, I said, well, how do we know how much it's going to cost Vermont to deal with greenhouse gas emissions? We don't know that right now. And they didn't know that when they wrote the statute. And so to solve that problem, right, to answer the question of the denominator on the left-hand side here, the statute sets forth in section 599, sets forth in section 599C, a report from the state treasurer on the cost of Vermont of the greenhouse gas emissions during the covered period. And it gives the state treasurer until 2026 to come up with that number. So a couple things jump out at me right away, right? And I should say I've omitted some language here that describes who the state treasurer should be consulting with in arriving at this figure. And it's all of the expert agencies that you would expect to see there. But the important point here, at least for me, and thinking about this as a wave of climate litigation that we can see coming, right, that we've created by this statute, is that it's not going to be until 2026 that early 2026 that we have a final administrative decision, a rule saying what that number is, what the cost to Vermont is. And I would argue, or I would surmise, that it's very likely that that decision is itself challenged in court, and that could hold up this process even further. So we're talking about at least 2026 as the earliest that we might see any type of orders issued under this new Vermont Climate Superfund Act, and we start to see litigation, coming out of the appeals of those orders maybe later in 2026 at the earliest, right? So still 2 years out from where we are today. Is it possible that they move quicker than that? Certainly, right? The state, it just says on or before, right? It's possible with pressure, the treasurer could be motivated to issue that report much quicker than 2026, and then we can start the ball rolling earlier. But until that report is done, we're missing the denominator here, and you can't solve an equation with two variables on the same side when it looks like this. So you need that cost to Vermont decided before we can even begin to make demands of PRPs. The other parts of this equation, I should say, with respect to the share of greenhouse gas emissions and total greenhouse gas emissions, they're leaning on other previously conducted research to deal with those problems. It's a little bit more straightforward than the cost piece of this, I would argue. And so I'm really waiting. I think that the holdup here is really going to be that that report by the state treasurer. Now, once the funds come in, what are we using them for? The statute puts forward very straightforward sort of ways that it's acceptable to use the funds recovered through the Climate Superfund Act, right? Qualified expenditures for climate adaptation projects and administrative expenses of the program are like the first thing that they're expected to pay here. But there's also existing state hazard mitigation plan that has climate adaptation action in it, which we can now use the fund to pay for. Implement community resilience and disaster mitigation grant program. So instead of paying directly through the fund, provide grants to individual communities within Vermont to improve their own climate resilience and disaster mitigation with respect to climate change. The fund is obviously going to look a little bit different in its administration than the way CERCLA does, right? Because we're not talking about cleaning up a particular site, right? We're talking about, in some cases, fortifying against climate change communities in Vermont, making them more resilient, and in other cases, rebuilding communities that have been impacted by floods, drought, all things we've seen within even just the past few years. Let me just mention one last thing about this Vermont statute before I move on to the other part of this oncoming third wave. And that's that this Vermont statute explicitly includes a savings clause that leaves viable all of the tort litigation that I mentioned in the second wave, right? So the state law tort actions could have been precluded specifically by the statute, right? The statute could have explicitly done away with them, right? We could have preempted them at the state level, at least in Vermont, and that's not the direction that the legislature chose to go here, right? That's important because it means that even as we're waiting for the treasurer's report and the initial demands to be made and the litigation around those demands, and maybe this entire statute being challenged in court, the other litigation initiated by the Vermont Attorney General is still going to be ongoing, right? And same as far as I know in New York and other states that are considering this are being pretty intentional about including these savings clauses. I will say this is a deviation from what I proposed in my academic work at the federal level, where I suggested that including a explicit preemption clause could be used as a bargaining chip to get more votes, right? Politically, taking all this litigation off the table through some kind of massive preemption could get senators or congresspersons from states where they would be less receptive to imposing this kind of liability. Maybe they're interested if it does away with these what they consider to be nuisance litigation against companies that do business in their states. So that was something I talked about in the paper. If you're interested in it, you can look at it. But on a state by state level, it makes a little bit less sense. And Vermont, I think, did the right thing here and kept these parallel tracks going, at least while we see how it plays out over the next few years. So that brings me to the last bit. And again, this is another sort of wave that I had written something about a long time ago. This is 2018. And this part of the wave is a little bit different than anything else we've talked about because it's a criminal law piece of the wave. So I started talking about this or writing about this in 2018, with respect to, statistical deaths, lives lost as a result of climate change, and whether or not that could provide criminal culpability for government actors that refused to address the problem. That was the initial idea, and these gentlemen came along and recently and really perfected the idea and took it to a place that I'm really grateful they did and played it out in a much more practical way in a piece that came out in Harvard Environmental Law Review just last year called Climate Homicide. And these gentlemen, one is from the George Washington Law School. The other one is at Public Citizen. They've been doing, you may have seen these presentations all across the United States for the past year or so, at various law schools, talking about this theory of potential criminal liability, not just to law students and law professors, but also to local prosecutors who might bring these cases. And I think the most interesting way to think about this is to look at it very quickly, because I know we're getting close to the time. Very quickly look at how this might be applied to, one particular instance, right? So and I think this one is relatively straightforward and illustrative, as some others commentators have suggested who are thinking about this issue, right? July 2023, we had a heat wave of historically bad proportion in the southwestern United States, and I'm focusing here in particular on Maricopa County in Arizona, where there were 645 heat-related deaths during 2023, is 50% increase from the year before. And as you can see from the graph, they've been having increased, as you might expect from climate change, heat-related deaths for the past decade or so. But the heat wave that struck in 2023 in June, but really primarily in July, extending into July, was particularly lethal, that specific heat wave. It alone resulted in hundreds of deaths in Maricopa County. And so the question is, could the people responsible or the entities responsible for the global climate crisis be held responsible under Arizona's reckless manslaughter second-degree murder laws that punish causing death through conduct that is reckless or that manifests, quote, extreme indifference to human life? And obviously, this would be a completely innovative theory of liability, criminal liability in this context. No prosecutor, to my knowledge, has yet pursued a case like this. But it's useful to, as I said, this theory is being pushed around the United States right now. In my opinion, it's just a matter of time before one or two prosecutors try it because of either a particularly catastrophic climate-induced event or because political pressure and the inability to do anything about the climate crisis through any of the other litigation or legislative or regulatory means that are currently out there are all failing, are not doing enough as far as their citizens are concerned, you might see this happen, and I would be shocked if we didn't. So in the Arizona context, right, we're asking, can we make a causal link, right? And it's important to note that a defendant can't avoid liability just because somebody else, some other person was also a contributing cause, right? So even though you could say, the climate, the biggest fossil fuel producers you might target here, say, well, everybody drives a car, or everybody puts a little bit of fossil fuels into the air. Well, that's not going to completely absolve you from liability. Other contributing causes can, right? In this particular case, right, the Maricopa County of Public Health recorded hundreds of deaths as heat caused into July 2023. And importantly, they listed environmental heat as the direct cause of death, not just a contributing factor. So when we're thinking about causation here, we have a lot of people who died just because of heat, right? Not because of some other complications of aging or disease or what have you, right? We also have a bunch of climate attribution studies that found that this particular heat wave in Phoenix would have been virtually impossible if not for human-induced climate change. Then we have what those of us who study this know of as the Climate Majors report, which shows that a very small number of fossil fuel companies are responsible for a large portion of all human-generated greenhouse gas emissions. So we know who the potential defendants are, right? That's the last link in the causal chain. They have continued, they spread this disinformation, as I mentioned earlier, and they've continued to do continue to sell their products to emit carbon, and it's at the core of what they do as a business, right? Obviously, there's going to be a massive backlash in terms of a defense strategy to any kind of prosecution like this, but I'm putting this out there so you can see where the causal chain gets put together in terms of potential criminal liability that we've been looking at. All right, so we've talked about the first wave and its failure and the wipeout at the Supreme Court. We've talked about the second wave and the state tort litigation. And now I've just talked to you a little bit about the third wave and how Vermont is leading the way with respect to statutory liability. And there are some other scholars and prosecutors out there who are looking at potential criminal liability as well as part of this third wave. So with that, I'll turn it over to your questions. I'd love to hear your thoughts on this and also just talk a little bit more in particular, if you want, about the Vermont Climate Superfund Act or anything else that's on your mind.
Thank you, Anthony. And Brian, my colleague in IT, if you would mind starting my video for me. Perfect. So thank you, Anthony, for that and for really a very comprehensive sort of magical mystery tour through the different waves of litigation. And I think all of us watching appreciate your graphics. That's very much appreciated. So I think that we do have one question in very timely question. This is a very timely talk, of course. Yesterday was the anniversary of the major floods a year ago that really were a major part of the impetus for the Vermont Climate Superfund Act that you described. We had, well, luckily less flooding yesterday as the remnants of Beryl sort of barreled up the east coast. We did have some pretty significant flooding in the state, notwithstanding the fact that it wasn't quite as widespread. There was some very, very serious flooding in Barry, and some rivers were at major flood stage. So we certainly saw those impacts, and we also unfortunately had a fatality in the flood. So the question is, when you think about an incident like that, and the entities that cause climate impacts potentially being liable for deaths, can you make that, analogy to flooding? What would the sort of, proximate cause liability for that death might be for the companies. And I think that maybe goes more to your the criminal liability discussion, but it certainly seems like it has some relevance as we think about these are huge impacts here in Vermont, right? Versus the heat dome and those sorts of public health impacts. We have these massive floods. That was a major impetus. How do you think about that liability?
Yeah, that's a good question. So let me start with the criminal, and I'll back into the Vermont statute, which I think is more applicable here, as you suggested. You know, as I walk through the causal links in the Maricopa County situation, one of the reasons that that's being pushed forward by some of the people advancing this is because the link is so direct, and there's documented government reports that say this is because of climate change, right? And I'm not aware of what was documented with respect to the flooding in Vermont. I witnessed some of it firsthand, but I haven't done any research on the follow-up and how they, you know, what they attributed it to. But to the extent that you could find if there are government and/or research documents that can tie that flooding directly to climate change, then you're in a situation similar to the Maricopa County situation. Without that, you are still one further step removed, right? You've got to do that initial work to tie the flooding back to climate change and the emitters that cause climate change. Now, perhaps, you know, not in the criminal context, but in the tort liability context, that's, as you suggested, part of what's motivating the Vermont legislature to pass this Climate Superfund Act. Because as I mentioned, that act has strict liability. That strict liability is based on your emission of your contribution to greenhouse gas emissions. Right? It's not based on, you know, whether we can tie those greenhouse gas emissions to the flood, right? Tying the greenhouse gas emissions to the flood is part of that report that the treasurer is doing on how much it's going to cost Vermont, right? Which is an administrative determination, which, as I suggested, probably will be challenged, but under a much more deferential standard than the type of evidence you would need to prove up in court, tying the two things together, right? In other words, if the treasurer and in consulting with the agencies in Vermont conclude that the costs of dealing with that flood were attributable to climate change, and they have a scientific basis on which to make that conclusion, and it's a reasoned conclusion, and there's all of the evidence in the administrative record, I would argue it would be very difficult for that kind of a determination to be overturned in court as arbitrary and capricious in using the federal standard, right? And so once that determination is made, the liability for those damages is just based on whether or not you emitted greenhouse gases, and that's the only part that becomes a subject of the statute's processes, where you get an order to payment, and then you could potentially appeal in court. Then you're just litigating, you know, how much are you paying at that point, and I think that's why the statute is set up that way.
That's very compelling, Anthony. And I think one sort of follow-on question that I would have, you know, is where we have this we very clearly know the producers that are responsible for various quantities of product and selling that product into the marketplace, developing it. I certainly have heard the discussion, and this is sort of part of the history that I'm sure you're very familiar with, of individual responsibility for climate impacts, that we sort of all know that what we're doing causes climate change by sort of running our lives in, you know, the ways we choose to do. Many people choose to maintain having internal combustion engine cars and those sorts of things. And we certainly have heard the industry, including in Vermont, talk a little bit about how, you know, they develop a useful product, and it's actually a shared responsibility with individuals. And so why is it fair? I think is a line of argument that we've heard. So I was just curious to know how you think about that in the context of you know, a CERCLA-like mechanism.
Yeah, so a couple things. One is just to tie it to CERCLA really quickly, and then I'll zoom out. In CERCLA, that is also true. I mean, it is very hard to argue that the contaminated sites that gave rise to CERCLA liability that we were concerned about in the 80s when we passed CERCLA were contaminated solely because these companies just wanted to use chemicals like for fun, right? They were using chemicals because people wanted to buy the products that were made with those chemicals. So in the same way, they could have made the argument that, hey, we're just doing what people want us to do, so they should have to pay for some of it too. And that wasn't baked into the cost of the product when we sold it, because we didn't think we had to clean it up when we made the product. And so now you should ask the consumers to pay us based on how much they bought. Like, you could imagine that argument being made, and it just doesn't. It hasn't held water in that context, and I think the same thing is true here. The other thing I would say is that, just zooming out on the climate context, is that the whole narrative around personal responsibility for climate is, as many of you probably know, a narrative that has since its inception basically been pushed by the fossil fuel industry as a way to sort of absolve themselves of responsibility and push that responsibility down onto individual consumers, and make everyone feel like it's their fault, and they should do something. They should do what they can for the environment, which I'm not saying absolutely reduce your carbon footprint, don't contribute more than you have to emissions, but you are not the problem. I often tell my students that when this comes up in class, because some of them feel like this sense of hopelessness because anything that they do individually is never going to be enough to combat the problem. And that can often lead to, like, well, I'm just going to consume away, which is also not a great answer. But, just know that internal tension and some of that emotional conflict that students and others who are concerned about the environment feel, was put there intentionally for nefarious reasons, right? To get you to turn your focus away from who's primarily responsible.
Yeah, for sure. And we did get another question that maybe goes to some of the potential sort of responses to this type of legislation, whether it be at the state or federal level.
Yeah, sure.
What about the fact that we're just sort of adding costs that will ultimately be borne by consumers, who pay for the products? And I think, the analogy to Circle is really helpful. So I'll that's definitely in one of our commenters' concerns, is that, who's going to pay for the extra price that the fossil fuel producers put into their products? That's us. So that seems also, problematic potentially. So what's your take on that?
Yeah. So, like you said, there's a good analogy to CERCLA, and we can talk about what happened in the wake of CERCLA in terms of a lot of companies declaring bankruptcy, and you had a lot of consolidation in the chemicals industry and other manufacturing industries. And you might see some of that here, although I'd argue there's already a lot of consolidation in oil and gas and coal. I think the more compelling answer here is actually, like, for a lot of these adaptation costs, you, the taxpayers, are already bearing those costs. I mean, I live in Portland, Maine. At least in my own community, we're spending millions of dollars to shore up our waterfront, our working waterfront. That is, sea level rise is threatening on a daily basis, right? We've had worse floods this last winter from storm surge and sea level rise combined than in any other year I've been here. The result is, we are going to have to do a lot of work on the waterfront, on the harbor, to make sure that doesn't get worse in terms of its impact on our infrastructure in years past. We've had to do a ton of work on our sewer system and our ability to hold storm water as a result of these events. And all of that money isn't just falling out of the air, right? It's primarily coming from taxpayers. And some of it's not even coming from taxpayers in Portland, for those people who are concerned about the property tax implications and the regressive nature of imposing some of these taxes. The taxes that are paying for some of these adaptation projects are coming from state level, adaptation grants, and then even higher than that, federal level adaptation grants, like from the Inflation Reduction Act, for instance. And where's that money coming from? I mean, it's not. None of this is. I mean, some of it may be being borrowed from countries, right? I don't know, but there's no version of a future impacted by climate change that doesn't cost trillions of dollars, and that doesn't cost the taxpayers trillions of dollars. Now, we can either decide to pay those costs directly, but through the government, or we can try to spread those costs to some of these producers and capture some of the profits that they're currently capturing for their own benefit and put those profits to use to solve some of this problem.
Well, I think that that's very, very helpful, Anthony. I think that a lot of those arguments were well ventilated in the state house in Vermont, because I think there was certainly that threshold concern, like, you know, you're just charging fossil fuel companies a bill that they will then pass on to consumers, and I think that's it's a nuanced answer, but it's really important, and it's also, it was very persuasive to a very significant victory here in Vermont, which I think, you know, we can take some solace in, maybe, that we had a tripartisan you know, veto-proof you know, supermajority in the legislature that supported this in light of those major costs that you know, have been visited on us for years, but particularly last year, and again, unfortunately, this year. Final question for you, Anthony, as we come to the end of the hour. How do you see this playing out with other states? And you know, your idea your idea for the federal bill obviously has some political challenges at the moment,
Yes.
but you know, there does seem to be some momentum around this concept, and I'm wondering what you see there.
Yeah, it's a great question. So I could see some other states beyond New York and Vermont sort of falling in line. States with, like you suggested, you have these catalyst events that impose significant costs on the state in terms of rebuilding infrastructure. And I could see that being the motivating factor. You know, in terms of the federal level, I like to think about sort of the laboratories of democracy model. And the more that you see this developing in the states and iterating, you know, states changing a little bit as they see how Vermont's works and New York's works, then if you get enough of that activity throughout the country, you might see that the idea being brought to the federal legislature in sort of a more perfected form. That would be the hope. As you suggest, right now, at the federal level, there's probably very little appetite for something like this. Their attention seems to be elsewhere. And, you know, I wouldn't expect it to be this quick coming from Vermont all the way up to the Congress and the Senate. But, you know, a couple of years down the line, it's certainly a possibility.
Well, I mean, I think, Anthony, I appreciate that optimism. I share it, I think. You know, I do want to recognize we're out of time and we need to wrap things up, and we appreciate the audience participation as well. And we're really grateful to you, Anthony, for your presentation. So thanks to everyone for joining us today for Hot Topics. Our next one will be next Tuesday at the same time, same location. And have a good day, everyone.